Joining us now, Christopher Green, law professor at the University of Mississippi Law School. Good to see you there, Professor.
Good to see you. Looks like I'm labeled as Lynn Fitch on the video, but okay, there we go.
We got you. We got you. Yeah, she's coming on at 12:05. We just made you the Attorney General for a brief moment there.
I didn't use my power. I had it for just a second, and if I'd known it was coming, I could have used my power for good, but I didn't use it for evil, at least.
All right, we wanted to discuss with you today this case, Buck versus Reeves. The U.S. Supreme Court this week decided not to hear this case concerning the redistricting process, the most recent of Mississippi's congressional districts. Tell us about, I guess, the thesis of the case, what the plaintiffs alleged, and give us some background on that, please.
Yeah, so this has got some background. So back in 2000, we had a federal lawsuit. So both in 2000 and in 2010, the legislature does not redistrict. Okay, so in 2000, we lost a congressional seat that was very, very important that we come up with something, because we've got to decide. We don't have any four-district maps. In 2010, they had some four-district maps, but they were malapportioned because of population changes. So basically so in 2000, the court comes in and redistricts. They come up to the Supreme Court, and the Supreme Court in 2003 in this Branch versus Smith case says that was an okay thing to do. You can draw the districts. You don't have to do at large. Then in 2010, the legislature doesn't redistrict. So that same case, they came back to that same case and said, okay, modify the injunction to account for population changes, shifts among the districts. Then in 2020, we have the census of 2020, but then in 2022, the legislature does redistrict. Okay, so we have some plaintiffs who have some claims under the Voting Rights Act. So obviously there's claims about one person, one vote. The old districts couldn't have worked. And we have a legislative district as well. So basically what the court did is say, we're going to dissolve our earlier order telling the state to have these four districts that made sense in 2010. The plaintiffs, so the people challenging the new legislative maps, they said, we want you, this court, now to consider claims of racial gerrymandering, saying that there should have been a different arrangement of African-American voters. That's the chief thing they're concerned about. So we got Benny Thompson's district, which is has enough African-American voting population to elect him, but they wanted a somewhat different arrangement that would make it perhaps more likely to have influence on a different district. So a bunch of complicated claims specifically about this map. These plaintiffs wanted the same court to be doing it so that the remedy would be just a tweak of the 2010 maps. Basically, what the court said, the three-judge court said, well, we're going to dissolve our order. The legislature has their new maps. If you want to challenge that map in a separate lawsuit, you can do that, but you can't do it just as a way of trying to get the map back to as close as possible to 2010. So essentially what the lawsuit was about, what the issue was about was, are the claims of racial gerrymandering taking place against a backdrop, a baseline of a comparison of the 2010 maps that the court did, or are they going to have to prove a racial gerrymandering claim kind of based on what the legislature did themselves? So it was clear that the challenge was, it was clear in the early 2022 that they weren't going to resolve things in time to affect the 2022 congressional elections. It is going to have to be a separate lawsuit. There's, I would think, plenty of time to have a separate lawsuit making the same claims in time for the 2024 elections. But basically, what this decision, the upshot is that claim is going to have to be considered in a different lawsuit. So it's not going to have the 2010 maps necessarily as the baseline of comparison. So, oh my goodness, I could have given so much more additional boring detail, but that's,
well, is this the reason, Professor? Is this the reason? What you just said concerning the 2010 map, is that the reason the Supreme Court said, no, we're not going to take this thing up? Well, I mean, what's their basis for that?
So the reason they decided not to take it up is the state came in, and the Mississippi Republican Party, they both said, well, what you should do is dismiss this appeal for lack of appellate jurisdiction. So this is 3 judges. This is Judge Jolly and 2 district judges, Judge Bramlett and Judge Wingate. And it goes straight to the U.S. Supreme Court. And they said, well, first thing, you should dismiss this because this isn't the right time to hear this appeal because you don't have jurisdiction over an appeal from a dissolution of an injunction. In the alternative, you should just summarily affirm. Look at what they did and say, yeah, they got it right. What the U.S. Supreme Court did was dismiss the appeal. So they said, okay, we're agreeing with the argument that they don't have jurisdiction. The argument, that argument was based on the list of words in the jurisdictional statute for these 3-judge courts. So there's a difference. So ordinarily, when you come into a trial court and say, "Hey, I want an injunction. I want a different injunction," they say no. In an ordinary case, whereas with a single district judge, you can go straight up to the Fifth Circuit under 1292. But there's different rules about when you can immediately go up to the U.S. Supreme Court from a 3-judge court, in part because they don't want people just immediately running to the U.S. Supreme Court all the time in these 3-judge court cases. So it really turns on, just really, really technical language in the jurisdictional statute. So there was a suggestion. I don't think it's available now, but there was a suggestion that they could take an appeal to the Fifth Circuit from this 3-judge court. But I'm not sure if the plaintiffs are planning to do that. Just starting over with a new lawsuit and saying, hey, look, we think this is a racial gerrymander for X, Y, and Z. Maybe trying to give up any particular salience for the 2010 baseline because it's the court that actually picked those lines.
We got a couple of minutes
doing that, but
we got a couple of minutes left, and this may be a question you can't answer in 2 minutes. But essentially, what my understanding is, Professor, the plaintiffs are saying is we got the highest per capita composition of minorities, black people, right? In of all the 50 states. We've got the highest percentage of our total population is represented by black people, but yet our congressional districts don't reflect that. Only one has more black people, voters, than of the 4 that we have. And so what they're maintaining, I believe, is that that's unfair. Is that essentially right?
Yeah, that's the claim. And the Supreme Court did not say that they disagree with that claim. What they said this week was, we're not going to hear the case in this setting. So they might be open to that kind of claim in a future case. We really don't have any information about the receptivity of the court to that kind of claim. And actually, the 3-judge court here, Judge Bramlett, said, I think this claim, might have some merit in a different posture. Judge Wingate dissented, so there's definitely some support among the courts that, hey, this claim is worth looking at, just not in this posture.
So it sounds like the case, the concept at least of the argument may have some life left in it. We may see it surface in the form of a new case.
I would be surprised if it didn't resurface, because these claims they get litigated endlessly.
Yeah. So just looking at the maps of our 4 congressional districts, District 2, which Representative Benny Thompson hails from, has 65.9% black population, 30 white. The other 3 are all just about opposite in the same amount. So, but yet our state has 38% black population overall.
Yeah. So I mean, it's about between 25% and 50%.
Yeah.
So if you
Yeah.
have 1 out of 4 and 2 out of 4, this is part of the reason that some people are critical of districting. So I mean,
Yeah.
there's a lot of different mechanisms we could do. We could just have a system where you let everybody in the state cast one ballot, and then just take the top 4 people. And you could have give everybody 4 votes, and then take the top 4 people.
Wow.
So there's a lot of different ways we could do it if we got away from doing districts. Given the Voting Rights Act, given a long history of districting, it's apparently going to be a suboptimal solution.
Appreciate it, Professor. Take care. We'll talk to you soon. Thank you, sir.
Enjoyed it. Thank you.
Yes, sir.